I know, Tommy, you wanted to clarify something, so I want to give you the opportunity to do that.
Yes. You see, Judge, what happens is that initially we started by saying the issue of restitution and that of communal tenure are two separate and distinct issues. In restitution, an individual, and that would include companies, states, etc., and a community can claim. A community that currently lives in Soweto, people who, after they lost their land, were dispersed and are currently living in Soweto. There's no traditional leader. They can claim land as a community. The definition of what constitutes a community in restitution is set out in judicial precedents. The definition is contained there in the Restitution Act as well. Then, on the other hand, you then have communal tenure. Communal tenure would apply predominantly in the former homelands. Now, that is where you're going to find the traditional leaders, because remember, before 1994, black people were only confined to the 13% of the land. And it is there that there are issues of communal tenure. We have established in excess of 1,300 communal property associations that over 3 million hectares that have been awarded in restitution have mainly gone to communal property institutions, which would be communal property associations and trusts.
But there's an anxiety now that you're rethinking that. That's the question. The minister appears to be rethinking.
In the context of communal tenure, not in the context of restitution. Let me put this to you,
and I'd like your response to this. In the Cater litigation that you were talking about,
yes.
There's a 2012 affidavit by a senior government official who says, despite the optimism with which the settlement agreement was done, the process has now encountered fierce objections by the traditional leaders who state that the agreements transferring ownership of rural land to community-based associations undermines their authority. The minister has now issued instructions that discussion for the implementation of CLARA are still continuing and no land should be transferred until this process has been finalised. Now, is that correct?
Let's look at the context under which that affidavit was deposed to. It was not very long after the Department of Rural Development and Land Reform had been established, and the Communal Land Rights Act had not been struck off as unconstitutional by the Constitutional Court. So what some members of civil society and what some of the academics are doing is to use a case that is currently being finalized. The land that is communal land, especially in the Eastern Cape, a lot of it is unsurveyed, unregistered. So to transfer the land to a communal property association in terms of the agreement is something that is being done.
I accept that, but I'm saying when somebody who's senior signs an affidavit like this, only a year ago, surely it triggers off concern, and I'll tell you why. Because there's been a huge amount of controversy with the traditional courts bill, as you well know. Yes. I know that's something different. But the anxiety has been that the traditional chiefs, as a result of being stymied through all of the opposition to that particular bill, now are very anxious that if there's going to be communal land rights, that in fact they should have a very significant hold over that, precisely because they've been stymied with regard to the traditional courts bill.
In September 2011, we published the Green Paper on Land Reform that proposes a single land tenure system with 4 tiers, one of which is communal tenure. And there was a national reference group that was established, made up of all land reform stakeholders, that was working and negotiating, developing the policies. And what is meant in the affidavit is that through a structure like that, traditional leaders were putting forward their ideas. And we were still just like we are now, we are still negotiating, debating, discussing these policy proposals.
All right, but you see, that's what I wanted to say to you is, there's been serious controversy. The traditional courts bill, for example, is hardly something that was unanimously acclaimed throughout the nation. Been massive protest about that. And that's because, as I understand it, people are anxious that the traditional chiefs should not have an unfettered discretion in all of this. And so the suggestion is that, having been somewhat anxious that their powers are not quite being implemented because of the slow progress of this bill, now they're very anxious to keep control of land restitution.
No, I think
that's the criticism that's being offered.
It's misplaced, that criticism, because as my colleague has said, the recipients of restitution awards are mainly two. It's individuals and communities. And communities outside the traditional community areas and communities with no traditional leadership. We are saying in communities with traditional leadership, people will decide which way to go. And if they decide to get their land in terms of CPA, there's going to be problems. There will be two bulls in one area. And then, secondly, what you are doing by going that route, you are destroying the ontological character of communal tenure.
Oh, but the communal tenure is the question of communal tenure through the community, not communal tenure which is in a sense disposed and dispensed by one person, being the leader.
As I've said, it's not one person who dispenses with
all right,
justice
I got
or
you.
whatever. It's not like that. It's a misperception.
Well, Nulundi, as I understand from my guests in Johannesburg, is that number one, the department is saying, somewhat contrary to what you're suggesting, that they've been extremely anxious to try to get the balance right, that they're actually worried about these issues, and that in fact, even in the traditional areas where they're traditional leaders, that, as you've heard, they're not suggesting for one moment that these communal property associations should be rejected. Is this not then a bit of a storm in a teacup?
Well, the thing is that if this is the feeling, the policies that are coming out of the department are not reflecting that feeling.
What would you want them to do?
What would you want them to do? Speaks about vesting in traditional councils land administration powers. It speaks about using the institution of traditional leadership as a base around which to construct communal tenure land reform, land policy. And the other concern is that restitution being reopened in this way, and with these conversations around the fact that having a communal area within a communal area undermines the authority of traditional leaders is very concerning, because what that speaks to is that people who live in the former homelands and in areas that operate under a communal land system are not subject to the same democratic rights as people who live in areas that are not under communal land.
But are you prepared to accept?
So are you sorry?
Are you prepared? Are you prepared? Sorry, I can't talk at the same. I can't talk at the same time as you. I can't talk at the same time as you. I've got to ask you this: are you saying that you're not prepared to respect the idea that there are communal chiefs, traditional chiefs, who have some authority, that this is deeply embedded within the mores of certain communities? That's what the doctor's saying.
No, I absolutely accept that. Absolutely. That the thing is that when it comes to systems of customary law, systems of traditional leadership, it is extremely closely linked with people's identities and how they identify themselves. So there are absolutely traditional leaders who are more than willing to have communal property associations coexist within their society. Our concern is where you are pulling that apart, where you are saying that where you have traditional leadership, you cannot have communal property associations. And that's what the communal land.
So what would you want the department? What would you want the department? What would you want the department to do, which it's not doing now?
They really need to consider a system that allows for both to exist. People who live in areas that are former homelands are also South African citizens, and so they are entitled to full democratic rights in the same way as people who don't live in an area of communal land systems.
Briefly, do you agree with that? I'm sorry, running out of time. Do you agree with that?
We are actually going a step further. Because we are saying there will be, we are proposing institutionalized use rights that will now go to the level of households, where household members would have clear and defined rights. There are proposals about substantive quorums in community meetings where decisions are going to be taken.
Right, well,
it's the community that will basically
We'll
decide.
be watching this space with a great deal of care, because this is really a very important question. I mean, we've gone 100 years since the 1913 Land Act. It's 100 years. We should be a lot further down the road than we are. There's no question about it. The real question now is, to whom do we actually bestow the rightful land? In other words, what entity, the traditional chiefs, communal associations, how do we get the balance right? And what role democracy, the rights of ordinary people in these communities to decide for themselves? And of course, we've got a whole range of competing arguments between the traditions of the chiefs and that which is enshrined within the Constitution, and, as you've heard, some of the other arguments. The department appears to try to get that balance correct. Has it done so? Will it do so? Judge for yourself. Goodbye.
News that moves. enca.com.